When I was a kid, I had a book with me everywhere I went. My parents didn't threaten to sue the book publishers for writing content that I wanted to consume. It seems a dangerous road to go down to say, yes,
Yeah.
we are addicting kids to information platforms and speech platforms. It's just one half a step, maybe even less down from well, we're just, these kids, they're reading too much.
Welcome to Law and Chaos. Today, we'll be talking about the latest effort to restrict internet speech for the children, specifically Utah's social media ban, which just got enjoined because you can't just get around the First Amendment by shouting, "We're doing it for the kids." We've got a lot to cover, so let's get after it. Hey guys, I'm Liz Dye. With me as always is Andrew Torres. Andrew, how are you?
I'm all right, Liz. How are you?
I can't believe it's Monday again. How is that possible? But here we are. Today we've got First Amendment lawyer Ari Cohen on with us to discuss NetChoice v. Reyes, which is a challenge to a Utah law which, as we said in the intro, regulates social media platforms. It would require the social media companies to verify users' ages and get parental permission before allowing access to minors, and then it restricts the kind of accounts minors can have. Essentially, the sites would have to card at the door like a nightclub, which is pretty weird considering the law's definition would include sites like LinkedIn.
Yeah, for your networking savvy teens. But look, I want to talk about those requirements for a second because on face, that's restrictive. But the way that this law goes about it is, I think, even more noteworthy. Okay, so first, let's talk about how it defines social media companies. This is Utah Code Section 13-71-101, and it says a social media service is defined as a public website or application that, 1, displays content that is primarily generated by account holders and not by the social media company. 2, permits an individual to register as an account holder and create a profile that is made visible to the general public or a set of other users defined by the account holder. 3, connects account holders to allow users to interact socially with each other within the website or application. 4, makes available to each account holder a list or lists of other account holders with whom the account holder shares a connection within the system. And 5, allows account holders to post content viewable by other users. And that definition is really going to come into play in our discussion.
Right. I mean, look, that covers more or less everything. And I'm not sure why you need a law to keep kids off of like LinkedIn or Facebook, right? I mean, honestly, those sites are so goddamn boring. I think they're self-screening. It's not like the kids are going to be hopping on there or anything.
Yeah, okay. But look, the way in which the law works is that the social media companies must, quote, implement an age assurance system to determine whether a current or prospective Utah account holder, because this is a Utah law, it applies only within its borders, even though it's on the internet, is a minor. What is that system, you might ask? Well, the law doesn't tell you, but it does say that the system must be reasonably calculated to enable a social media company to identify whether a current or prospective Utah account holder is a minor with an accuracy rate of at least 95%. How do they get there? You guys figure it out, right? But don't worry, if that still seems kind of impossibly vague, the law does say that social media companies will be required to, quote, implement a review process allowing account holders to appeal the account holder's age designation by submitting documentary evidence to establish the account holder's age range. I have no idea what any of that could possibly mean. And then, the sites have to review the evidence and make a decision. And look, we're going to get into this with Ari, but I think this law is deliberately vague on the means of age verification to try and distinguish it from, all the other failed attempts to age check the internet.
Yeah, I would agree with you. And I think that that's a deliberate effort at obscuring the contours of the statute to protect it from constitutional challenge. But obviously it didn't work. So, okay, the Utah legislature made a number of findings in support of this dumb law, which Judge Robert Shelby cites in a footnote. The legislators said the proliferation of social media services has led to the widespread collection and utilization of personal information exposing minors to potential privacy and identity-related harms. The addictive design features of certain social media services contribute to excessive use of a social media service by minors, impact sleeping patterns, academic performance, and overall health. Social media services are designed without sufficient tools to allow adequate parental oversight, exposing minors to risks that could be mitigated with proper parental involvement and control.
Citation needed, as they say.
Yeah, that's a lot of conclusory language. And also, if it could be mitigated with proper parental involvement and control, what the hell are the legislatures doing in the mix here? All right. And then the law, and as I said, these are all findings codified in the law. These are legislative findings, which they put in as 1371-102. All right. So it goes on to make this bizarre analogy between not issuing driver's licenses to 13-year-olds and regulating the internet that all of us live on, which would make complete sense if driving was a fundamental right protected by the Constitution, which it is not. So they say the state has enacted safeguards around products and activities that pose risks to minors, including regulations on motor vehicles, medications, and products and services targeted to children, and existing measures employed by social media companies to protect minors have proven insufficient. And no, you can't just say, well, there should be something here and yada, yada, yada over the First Amendment and say, well, we got to do it because the internet makes some kids sad.
I want to hone in on your use of the word kids. I mean, about that, because footnote 32 of the opinion notes that the definition of minor under this law, for purposes of Utah law, is an individual under 18 years old that has not been emancipated or married.
Yeah, Utah, way to play to every stereotype. But honestly, how is this going to be? You present your driver's license and it says I'm 16 years old, or you present your proof of age and it says I'm 16-year-old, so I would be a minor, except here's my marriage license. And so I can have unrestricted access to the. I mean, it's a
Bishop
very
Temple recommend. I'm sure.
Yeah, it's a very kind of sort of telling on themselves. I do want to circle back to something that I said because I made a joke about the internet making some kids sad, and look, I have a teenage daughter. I'm not unaware that the internet does encourage inappropriate body standards, particularly for women. I would not ever want to diminish the fact that there are lots of, and there are pro-anorexia websites. There are a lot of things that are, of course, harmful. I wouldn't want to kind of joke about that. But I do think the point that you can't restrict all of the internet because some of it has deleterious harms on some people. That's just not how America works. It's just not consonant with the First Amendment.
Yeah, I agree totally.
Okay, so in just a minute, we are going to get to the interview with our guest, Ari Cohen, unless you are a subscriber, in which case no ads for you ever. And if you'd like to become a subscriber, go ahead and hit us up at patreon.com/lawandchaospod or on lawandchaospod.com. For everyone else, we'll be back in just a minute. And with us today is Ari Cohen, a First Amendment and free speech lawyer. He's a nationally recognized expert in First Amendment law, defamation law, and Section 230. He currently serves as free speech counsel at Tech Freedom, which is a nonpartisan, nonprofit think tank devoted to technology, law, and policy, and the preservation of civil liberties. And we are so excited to have him here today. Ari, thank you so much for joining us.
Pleasure, as always.
All right, so we would be remiss if we had a free speech First Amendment lawyer on and did not ask you what you thought about Donald Trump's accusations that Kamala Harris incited a second assassination attempt against him. Is that correct as a matter of law?
I mean, obviously not. It's also just galling in its hypocrisy. For Donald Trump of all people to be crying that other people are inciting violence is it's a bit much to swallow. But no, I mean, Kamala Harris obviously has not said anything likely to or directed to inciting someone to immediately commit an assassination attempt against Donald Trump. And it's just he's just being a crybaby.
Yeah, he is. He is. I noted that he posted on social media 3 hours apart this morning. Fight, 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 and then a long whiny ass post complaining about Harris's inciting rhetoric against him and how he was safe thanks to the Secret Service. But he's such a whiner.
Yeah, I mean, does the temperature of politics need to come down a little bit? Would that be best for everyone? Probably, but I mean, Donald Trump, if he wants the rhetoric to be turned down a little bit, it needs to take a long, hard look in the mirror first.
Yeah.
Also, I'm not wrong that both shooters would be, right, are Republicans, right?
Yeah, I mean, that's the theory. Yeah.
I mean, it's just for somebody who loves the concept of the heckler's veto so much, right? Like, this is an actual heckler's veto.
Yeah, I'm always a little bit wary of, going by what somebody is, registered at or what they have posted, in the wildest conspiracy theory minds. Sure, it's possible that someone could tweet a whole bunch of things about liking Donald Trump to, throw people off the scent. But, let me be clear. People should not try to assassinate anyone. That's bad. I shouldn't need to say that. But to start blaming your political opponent for her criticisms of you and saying that you criticized me and therefore somebody tried to shoot me is just insane.
Yeah, speaking of the heckler's veto, J.D. Vance had a hilarious misinterpretation of it. He said if he is forced to stop telling lies about Haitian immigrants in Ohio, that would be the heckler's veto, which is so impressive. Really, what kudos to Yale Law for their illustrious grad.
I'm so tired.
I do want to echo that we are anti-assassination here at Law and Chaos. Like, that is the one thing we can all agree on.
That's just a bit too much chaos for Law and Chaos.
Right.
Exactly.
Yeah.
Exactly.
We are law and living chaos. There we go.
Yeah. All right. So let's get into it, because as you know, that there has been a proliferation of anti-speech laws to protect the children. Ari, are you against protecting the children? Why do you hate the children, Ari?
Well, I'm sure that people have plenty of different theories, but no, of course I'm not against protecting the children. But, we have seen time and time and time again that when laws are proposed and enacted, quote unquote, for the children, they're awfully bad policy. They're not thought out. They are carried on by a sweep of moral panic that allows legislators to basically justify whatever they want to do with minimal work, because they don't want to do the hard work of actually assessing what the problem is and tailoring a careful and nuanced response to it. They just want to blunderbuss through it. They get to when they say it's for the children. And, it's maybe not the most tasteful slogan, but it's kind of true that dead kids make bad law.
So can you flesh out what you mean by that one? Since as we've said, we're anti-assassination on the Law and Chaos podcast.
Yeah, we're also anti-children dying, I would hope. I would hope everyone is. But there's this pervasive theory that social media is literally killing kids, and any politician who gets within 100 yards of a microphone or a keyboard will tell you that. And the problem is that's just not true. We certainly have a mental health crisis in this country, but to say that this is all social media's fault and we can fix this all by reining in social media is not only not going to get us where we need to be, but also is just a really facile attempt at actually addressing a serious problem. And there's, frankly, there is scant evidence, as we'll talk about later, I'm sure, that this is actually a causal relationship here in the first place. But it's sexy, it's attention grabbing, it's headline getting. It allows legislators to beat their chest, and so this is the landscape we're living in right now.
Well, with that as a setup, right, the moral panic about social media and children, let's talk about what Utah in specific did in terms of passing successive legislation. You want to kind of flesh out the history of the Utah statutes that are at issue that we're talking about today?
Yeah, so let me make sure I'm getting my dates right, because you're right, it has been a process. Back in February 2023, the Utah legislature passed a couple of social media bills, one of which would have required all social media platforms to age verify every user and deny minors accounts unless they have parental consent. And, the other bill did some other things about civil liability, but this was the main government enforcement of clearly unconstitutional things. And, I warned that this was unconstitutional. I wrote to Spencer Cox when these bills were on his desk when he was deciding whether or not to sign them. I'm not sure he really was deciding. He had his mind made up. And I wrote to him and I told him all the reasons why, or at least some of the big reasons why this bill was unconstitutional. And needless to say, his response was not impressive.
Yeah.
He really just said what amounted to nuh-uh in the face of, several pages of well-cited argument, and was determined to do this anyway. He even went on PBS, or not PBS, I can't remember what he went on. Maybe it was PBS, talking about signing the bills, and threw up air quotes around First Amendment lawyers when talking about the pushback he'd gotten, like we were some kind of fanciful creatures that don't actually exist.
Scare quotes.
Yeah.
Yeah. I mean, you had a hilarious exchange with him on Twitter where you were like,
culminated in him telling me, "I'll see you in court."
And he did. Well, maybe not you, but yes.
You never can put too many eggs in the basket of someone who utters the word "see you in court." But
and Spencer Cox is a lawyer, if I'm correct.
He was at one point.
And now he's a politician who passes performative legislation.
Yeah. So lawsuits were filed, obviously, and hilariously, the state actually asked the court to stay the proceedings because they wanted to repeal the laws and replace them with something else. So that was, first hiccup in the road for Spencer Cox's "see you in court" theory.
Can I ask, because I would like to flesh that out for a second, because I actually thought that was pretty funny too, right? The law was challenged and the Utah legislature and the governor was like, okay, maybe this is a touch illegal-ish. Can we have a mulligan and go back and try and recraft this law so it would be less flagrantly illegal? And the court was like, yeah, okay, fine, go do that. And then they came back and it was it different?
It was different, but I'm not sure it was any better. Their approach was two-pronged. First of all, they kind of softened the age verification part a little bit by saying, you need to have age assurance within 95% confidence, which is just age verification by another name. Mm-hmm. And, you have to have all these minor account restrictions if a user is a minor that can only be overridden with verifiable parental consent, etc. And then the other half of it, on the civil liability side, is they made it so that it was a private right of action, which they really, they thought they were being clever about. They tried to pose that as, we're giving power to the parents, but really what they were doing was just trying to pull an evasion of facial constitutional review. They're, after Dobbs and all the cases about, not being able to challenge, private rights of action because there's nobody to really enjoin. They took their cue from that and said, okay, well, if we make this so that parents can sue and we'll have these rebuttable presumptions that can be overcome if the social media platform did age verification, then the platforms are just going to have to fight this out lawsuit after lawsuit because they can't challenge it facially. And that's how we're going to get them. And I have real concerns about that kind of legislative strategy. The prospect of just being able to undercut the First Amendment and chill expression and evade constitutional review just because it's a private right of action. I mean, the court has opened a massive hole in all civil liberties, and they're going to have to figure out how to rein that in because, that's going to be the new way to just go after whatever rights any particular legislature doesn't like, is just make sure people can sue about it and they can harass parties into, not doing the things the government doesn't want them to do, even though it's their constitutional right, because they just don't want to deal with millions of lawsuits. It's a real problem.
And We're going to take a brief pause here to pay some bills, unless you are a patron over at patreon.com/lawandchaospod or a subscriber on our Substack, lawandchaospod.com, at which point you will get an extended, super weedy discussion between the three of us in which we talk about standing and private rights of action, and I'm going to ask a question about Texas SB 8, and we're going to have a lot of fun getting in the weeds. Otherwise, enjoy the ads.
And we're back. So let's go back. Let's zoom out a second. Who sued here? Who were the plaintiffs in this case?
So there was the main plaintiff is NetChoice, who's a trade organization that represents a lot of social media platforms, and they have been very active in bringing legal challenges to a lot of these laws, both on the federal and state level, and usually alongside the Computer and Communications Industry Association, CCIA. And NetChoice was, of course, the main plaintiff, one of the main plaintiffs, along with CCIA, in the recent Supreme Court NetChoice versus Moody and NetChoice v. Paxton cases that were just decided.
Right. Those were the challenges to Texas and Florida's social media laws that were so blatantly illegal. They were like, you can't deplatform Donald Trump, but otherwise we're going to put you in jail and fine you $1 gazillion. So if I recollect, NetChoice was the plaintiff. NetChoice is, as you said, it's a trade association. It's got YouTube and in X and all of these main social media platforms, including Pinterest, because Pinterest always gets thrown in there when they talk about algorithms, because Pinterest is, of course, algorithm based. And those two cases went up to the Supreme Court and they got kicked for various reasons. I don't think the court really got too deeply into it because the appellate decisions were so flawed for so many reasons. They got kicked back. They'll come back up again. But the social media laws in the states have been enjoined for the time being. But, NetChoice is out there kind of doing the work. It's an important plaintiff because otherwise all of these organizations would have to, as you said, sue on their own account. And also the second set of plaintiffs, if I recollect correctly, were a bunch of users, and they have a slightly different interest. I think it was interestingly because it's Utah, it was a lot of people who were sort of part of polygamous communities that had kind of left the community and helped current members of the community exfiltrate also some LGBTQ ally groups that said, hey, if you kick
teenage content creators who were doing this, so they would be subject to the law.
Right. If you kick kids off of social media or make it, based on their parents' approval, then they kind of lose out because they don't have all of this help kind of exfiltrating from abusive situations. So, but those plaintiffs got barred. I think the judge said, no, you guys do not have standing, but said that NetChoice did have standing. Do you want to talk about why NetChoice did have standing and the other plaintiffs, the individual plaintiffs, did not?
Well, NetChoice has standing because the law directly regulates their member organizations. The law tells social media platforms what they have to do, and it says that the government can impose penalties against them for not doing it. And one of the reasons the court found that the individual plaintiffs didn't have standing is because a failure of what the courts call redressability. A court order could not really resolve the problems of those individual plaintiffs because the law only applies technically to the platforms themselves. So those individual plaintiffs can't really get anything out of this litigation, to kind of put it in oversimplified terms.
Right.
Until they're actually kicked off the platform or regulated or prevented from using it.
Right.
Yeah. So those are the individual plaintiffs. But Ari, as you point out, the law directly regulated the NetChoice member organizations, right? And this really seems to hit at two issues that are right within your wheelhouse in terms of the First Amendment and the unconstitutionality of various laws. And those are, we've talked to you in the past about parental consent laws to access the internet. And also, in this case, what I thought was an interesting wrinkle was laws that specifically target social media companies as opposed to other companies that are spreading speech on the internet. And if I read this correctly, the court basically said that's not just a technical distinction, right? You are actually discriminating on the basis of content, right? Like, and the one example that's present in the opinion is, if you send a push notification from ESPN about a sports team, right, that is not subject to the law, whereas a push notification from Twitter would be subject to the law. And so I guess the question that I have there is, the court viewed that as discrimination on the basis of content, which therefore triggers a strict scrutiny review under the First Amendment. And they didn't really get into the parental consent issue at all. So number one, do you think the court got it right on that? And then number two, how does this interplay with the question of discriminating on the basis of the audience?
Yeah, it's interesting. It kind of did seem like the judge maybe didn't really want to tackle the full age verification argument and kind of found an easier way to, do it from 30,000 feet.
Oh, interesting.
And, that could be, it's been a while since I've read the pleadings. It could just be a function of the arguments and the way the parties raised them. So I can't really say for sure that that's what the judge was doing. But that's what it struck me as. And, it was an interesting argument that, the interact socially provision, which is required for the act to apply, the judge said that is not informed by the technical requirements of what the platform has to do. It is a separate, this is the kind of speech that you have to convey to fall under the act's regulation. And the court said, well, social interaction, that's a content-based distinction. It'll be interesting to see how the appellate court sees that. It doesn't strike me as an obviously wrong argument. I think you could probably decide this case in another way that doesn't necessarily need that argument, but that's the direction the court went.
Yeah, Ari, unpack that for us a little bit, because it seems to me that you're suggesting that the 10th Circuit on appeal might find alternative grounds for affirmance, even if they don't necessarily buy the social engagement is content distinction that the trial court decided.
So, the other way the court could have structured this opinion was going through the decades of jurisprudence that we have about age verification and how it infringes on the First Amendment rights of adult internet users.
Mm-hmm.
And, this is well-trod ground. We did this all in the late 90s, then again in the early 2000s, when Congress was trying to keep quote unquote filth off the internet and prevent kids from seeing it. And they, passed all these laws, these child protection laws, wouldn't you know, and included things like affirmative defenses if a website verified the ages of the users and things like that. And they just got struck down time after time after time because.
And explain why.
Yeah. There's a big fat because after that, because adults have a First Amendment right to see and read this content, and they have a First Amendment right to do it anonymously, frankly, and to ask adults to identify themselves before accessing sensitive, controversial content would chill their willingness to read such content. And on top of it, there's the whole on the internet, nobody knows you're a dog thing, where you can't actually really verify that anyone is anyone online, because you can even provide a driver's license, but you have no idea if the person who submitted that driver's license is really the person at the other end of the screen. The court went over a lot of the, at the time, technical impossibility, which I posit is still very much in play, of actually verifying anyone's age, which makes that affirmative defense effectively unavailable to anyone.
Yeah, just to make that lucidly clear, we can't have an internet that is shaped by the fact, just as we can't have a world that is shaped by the fact that children might see something and it might be not great for them, right? The rest of us have a First Amendment right to move through the universe or move through our life as Americans and consume information and speak information even if it would be harmful to children, right? Our legal system, as it is constituted in U.S. America, is not set up to be childproof. That's not how speech goes here. And it's not how it should go. I mean,
the world can't be childproof.
The world can't be childproof, right? And when you have a fundamental First Amendment right to speak and absorb information, that can't be curbed just because children might see it and it might be bad for them.
Yeah, and one thing you said kind of is exactly where I wanted to go next, is that, in those late 90s, early 2000s cases, it was bad enough because we were talking about adults' willingness and chilling their willingness to read controversial content. Now what we have is not just reading, but also speaking. We are chilling actual, not just reception of information, but actual speech itself. The problem has only gotten worse.
Right. We're long past the PMRC and those warning labels on the records.
Oh boy, blast from the past.
Oh, but I wish Al Gore had won still, even though his wife was.
Oh yeah.
Nuts. Okay.
D. Snyder publicly made up with Al Gore in the 2000 election. So yeah. Said he could use "We're Not Going to Take It" at the campaign rallies. We've been talking about campaign rally music on the show recently.
Oh, I can't imagine why.
Obviously, yeah, rich vein to mine there. But let me make sure I understand your answer there, because with respect to age verification, this again is a question of strict scrutiny under the First Amendment, right? Because it implicates your core right of speech. And so the question again is, can you show that there's a compelling state interest and that the law is narrowly tailored to achieve that interest? And what you showed was that in an era that was significantly easier to regulate and over which there was less to regulate, nevertheless, the Supreme Court uniformly said, yeah, look, age verification fails both parts of that, right? It's over-inclusive in that you're forcing everybody to verify their age, not just targeting the children that you ostensibly want to protect here. And it's under-inclusive because it doesn't work, because they could just get, somebody else's driver's license and photocopy it, or a credit card or what have you. And so therefore, kind of on a practical basis, we've known for 25 years that requiring age verification as a gateway to content on the internet violates the First Amendment. Do I have that right?
Yeah. And, we've also known, and this has not changed, is that there are less restrictive means to accomplish the protection of children. And that is called parenting, and it's called parental control tools. It is not an answer that parents are not interested in learning how to use them or find it difficult to use them, or, just don't use them. The government is not permitted to say, well, parents aren't doing it and they're finding it difficult, and therefore we can step in and impose this ham-fisted obligation on the platforms to help the parents. That's not how it works. And there are far less restrictive things, and those things have not really changed a whole lot since the late 90s, early 2000s. And the courts, one after the other, keep noting that those less restrictive means are still there, and they're still viable. And so the courts are kind of given a little bit of side eye to some of these state legislatures on these cases.
Yeah, as a parent, can I just say, for God's sake, learn to set up whatever blocking technology you need to set up on your home router, and don't be a crazy person and ask that you're too lazy to parent. You need the government to block your kids from seeing content. That's a you problem. Try parenting. As a parent, I can say this, get your shit together. But actually, can I circle back to the law? Because there were so many things about it that it was clear to me that the legislators were so ham-fisted, as you put it, in the way that they kind of targeted, that they said that the things that made these platforms especially addictive, and look, we all do them. It's the endless stream, right? That it just auto-played videos, and it kept refreshing the feed, and all kinds of things that are kind of standard social media stuff, that it said this is so addictive, and thus social media platforms can't use it on our children, or you have to disable the autoplay for users under the age of 18 or something like that.
I want to question the premise, all the way at the beginning, and say, is there such a thing as being addicted to information?
Mhm.
Are we going to say that, we're causing kids to become addicted to reading more things
You're
on the
right. That's
internet? It's
bad
a
framing.
really,
It's bad framing on their part, but
it's
it's bad
yeah.
framing on my part
To
too.
be fair, Liz is addicted to reading stuff on the internet.
I-
Are choose your own adventure books
Beth.
addictive? When I was a kid, I had a book with me everywhere I went. My parents didn't threaten to sue the book publishers for writing content that I wanted to consume. It seems a dangerous road to go down to say, yes,
Yeah.
we are addicting kids to information platforms and speech platforms. It's just one half a step, maybe even less down from well, we're just, these kids, they're reading too much.
Okay, so I accept your criticism. Like, the platforms are not technically addictive within the, DSM definition, although that may get added. Internet addiction may get added, and pornography addiction may get added. I don't know, whatever. There's another point. The point is that there are these features of the platforms that autoplay and that, endless scroll and the algorithms, which are phrased as addictive. And if you don't want to call them addictive, like, as a person who spends entirely too much online and is terminally online, whatever you want to call them, the things that keep you there longer, that are programmed to keep you there longer, that the state wants to keep away from children because it's presumed that they have less willpower than adults. I got to say, my children are so much more willpower when it comes to social media. I really question that premise. But what did the court say about that? Because I thought that was really interesting.
Yeah, so the court said that, the law was really, if it actually is intending to prevent, the harms from these quote unquote addictive functionalities and features, then it's doing a piss poor job. It's woefully under inclusive. Disney Plus and Netflix, autoplay, Hulu, I think the court noted too, but somehow it's more of a problem when YouTube does it, such that they don't need to regulate the streaming services. But, I would even go a step beyond that. You know what also autoplays the next thing? Broadcast television, cable television.
Oh, good point.
And you know how they get you to keep watching the next episode or the next season? They don't resolve the story. They have cliffhangers. They have continuing storylines. Like, the whole point of media is to get you to want to consume more of it. Like, that's the entire point of media in general, down to literature and everything. It's just bizarre that we're in this crazy world of saying, oh my God, it is a problem that kids are looking at media and want to consume more of it. Like, yeah, of course they are. That's the whole point. That's why it exists. And, we might say that's less than ideal, and in some circumstances it might be, but, like, what are you going to do about it, really?
Okay, so we've praised the trial court decision. We've laid out some of the issues. This is going to be appealed to the 10th Circuit. The 10th Circuit is, in my view, a right-leaning court, but it's not a crazy court, right? But whatever happens at the 10th Circuit, it will then whichever party loses will petition for cert to an objectively crazy court. So I love asking this question of folks where issues don't always necessarily align on the left-right spectrum, and this strikes me as one of those that could fall into that category. What do you think ultimately this Roberts Court is going to look at with respect to the issues in this case, and what's the fate of the law going to be if and when it gets there?
Oh, man. Well, I make it a point to never actually predict what any court's going to do, because it's just a recipe for being wrong most of the time.
Yeah, but being wrong can be fun.
Really anything could happen. There's Free Speech Coalition versus Paxton coming up this next term, which has to do with age verification for porn.
Mm-hmm.
And that might tell us at least something of how the court's going to look at age verification. Now, granted, it is a very different circumstance between porn and social media. At least it is for many people, and I expect for many judges. If they're going to find a distinction, it's going to be between porn and not porn, because that's just something that preoccupies a lot of people. But, for better or for worse, we have precedent that, porn can be regulated as harmful to minors, and there's more restrictions that can be put in place sometimes. So, there is a distinction that makes it not a perfect one-to-one, but we should get at least a little bit of a sense of how the court looks at the current state of the technology, less restrictive means, and things like that. So I actually think that's going to tell us a little bit of something, but I expect that the state's going to have to make a much higher showing when it comes to social media access than it will for porn. So, if Free Speech Coalition prevails, against Texas, I actually think that's a really, really bad sign for the social media laws. Kind of an a fortiori argument there. I really, I hesitate to predict because, should be crazy out there.
Yes, it is.
It's hard to say, if the court adheres to precedent and past jurisprudence. I think it's very difficult to justify these laws, particularly given the lack of evidence of, an actual causational problem. I think it's going to be really tough. But
I see what you did with that if predicate there. Right?
Yeah. Motivated, judges can find reasons to do whatever they want. So, who knows? But, that hasn't been the case with most of this litigation so far. The judges have been pretty straight on First Amendment analysis in most of these cases. So it does give me hope that, we might see the judiciary kind of exhibit a temporary moment of sanity.
All right. Well, your lips to God's ears. Last question. Do you have anything to say to our buddy Spencer Cox, the governor of Utah, about since he was so clearly wrong?
I guess I will repeat one of the barbs he unsuccessfully threw at me. Spencer, you need better legal counsel.
Okay. All right. That is going to do it for us. Thank you so much, Ari.
My pleasure. Thanks so much for having me.
Okay, that is going to do it for us today. We will be back on Thursday with written content and on Friday with another podcast. See you in a couple days, guys.
See you then.
Law and Chaos Podcast is a production of Reyes Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright 2024, Reyes Media, LLC, all rights reserved.